here?
Well, they can see you here. The wood's down.
Just so I can set this down. I love that.
It's loading, so it's
Which camera? This one?
Yes.
Hello. If you're watching this live, you're either watching this on our YouTube, please subscribe and like, okay? Or you're live on our Facebook. I'm Jay Chacon. I'm the team leader, CEO here at KW The Lakes. Best brokerage ever, right? Right now. I'm super excited today. We're going to be discussing all things trust and probate. It's super important, you guys, right? Super important to have your trust in order. So I'm super excited to have Jennifer here to teach this lovely class. Everybody has packets in front of them?
No.
Yes.
No, you don't? Is there missing one right there? There you go. I'm excited. We're discussing all things probate today. Here, you get some swag and a pen. She came prepared. All right, without further ado, I'm going to introduce her, the attorney, the one and only. Give her a round of applause.
Very proud to be here.
Call her. All right.
Yes, I would love for you to call me. I love working with real estate agents. I appreciate your guys' efforts. Your work is a lot like mine. The way you work and the way that you get compensated is very similar to how probate works. There's a lot of conversation. There's a big relationship growing with this person, and you've got a lot to go through and get through, and there's a lot of decisions to be made, and you're waiting a long time for compensation. So that relationship professionally with us regarding work and compensation is very much the same. And I'm grateful to be able to talk to you about probates, but I also know you're very intelligent, and there's so much I want to share with you, so if you don't mind, I'd like to speak very quickly, and I'll slow down on things that I needed to go over myself to understand, and if you find me going too fast, just like say, slow it down, okay? And I have 1 hour, so that means I have till 2:10, which is a long time to talk, so I'll hopefully be done faster than that, because, if you have to go to the bathroom, really go for it, of course. But let me say before, you leave if you do that. I really want a strong relationship with you guys. I want to be involved with your closings. When you're celebrating a closing with your client, I want to be there. I can do gift baskets, I can do lunches, I can do all kinds of things to bring this information to these people. These people have worked, as you guys know, so hard to get this house. It comes up with a lot of money, a lot of stress, there's a lot of things to jump through. Then they got to get the insurance, and by then they're tapped out. I don't want to spend another dime. But there really is one more conversation that I would love for you to have with your clients that I hope you'll see why after we talk today. And that is put that house into a trust. All right, so this is kind of new for me, all this technology. I just wanted to share with you the 7 costly mistakes that families make in their estate plans. We live in perilous times in America. The reason we say that is because high divorce rates, right? We also have nursing home and health care long-term is $105,850 per year for a single room for the average person, right? So you can see where I'm going with this. An estimated 1 out of 4 bankruptcies are due to overwhelming medical bills. There are more than 53 million caregivers in America providing aid to family members and close friends. I am presently a caregiver. Because of poor estate planning, the courts are dealing with countless lawsuits over wills and poorly drafted living trusts. This is who I am. My name is Jennifer Venable, N.K. Nancy Catalina. I was born in Hemet, California. I have an office in Marietta and an office in Hemet. I'm an attorney at law. I went to law school when I was 47 years old. I'm a U.S. Navy veteran. I was president in my law school. I've been working in the legal profession since 2013. I'm the founder of my law firm, but my most valuable thing I want to tell you about myself is I'm affiliated with a group called the American Academy of Estate Planning Attorneys. That allows me, instead of diving into a book or stressing out about making sure I'm getting the right answer for my client in this situation that might be new to me, it allows me to speak to every single California attorney that's also a member of the Academy, and also every attorney that's a member of the Academy throughout the United States if it's a more federal issue. So I am surrounded by really smart people that I really, really appreciate, and this has really helped me, like this group helps you, support your business. And the most important reason I do what I do is listed up there. That's straight from me. I love helping families because bereaving is such a sacred time, such a sacred time. And to really cherish that sacredness, I'd like to help prevent the anguish that comes from the financial pressure that comes from the cost of losing a loved one without planning. Rather than being able to bereave, people are just buried in grief. And that is, to me, just so incredibly heartbreaking. To help families experience peace of mind, knowing that themselves and the families are prepared for all seasons in life is why I like what I do, and to help families navigate through the legal system like you help them navigate through buying a home. You probably enjoy that, helping people get through stuff they don't understand, and to fight for people when they need it the most. My most valued resource, as I've told you, is my academy membership. They demand a lot of extra education along with what the California requirements are for my education. All of our education is due February 1. Is yours coming up? All your education due? All of our CLEs are coming up. We have a high standard of requirements education-wise. Money Magazine recommends the academy to being a member. Nancy Orman recommends the academy. For people that are looking for estate planners is my point. If they're looking for a referral, they would say go to an academy attorney, and I'm just letting you know that we are recommended by Susie Orman and Money Magazine. And planning options, all right, let's jump to probate. So, here's the plan.
Supported in the crowd. I didn't know you were a Navy veteran.
Probate!
I'm a Navy veteran myself too.
I was a
So
corpsman.
A corpsman, huh? Aviation Ordnance Bomb Squad.
Smart. You're smarter than me. I just gave a lot of shots and behinds.
Just kidding, guys.
You got shots.
We're live.
So, what do people do? All right, so they bought this house. They worked their butts off. They got all the paperwork together. They got the closing, and now then they go get that insurance that they want to get, and then they're thinking, okay, we're done. At this point, they either have no plan to protect that house, or they're going to do a will, which will still put them into probate, or they'll have a trust. I call what I do, like, if you will, planning is just a hybrid of a living trust. So when I say estate planning, that umbrella terms means trust, will, healthcare directives, power of attorney, and documentation to release your medical records when necessary. If I jump around, just know it means a lot. I handed you this, I want you to keep it. It's a really good read, it's easy read. Take extras if you'd like, but what exactly is probate? It's a legal process whereby all the assets and all the debts and all the liabilities of an estate has to be managed and has to be reported to the court because there's been no plan in place. So the court is now involved and your entire life is public. And then after that's all done, then the money that's left over after paying for all these costs, attorney's fees, probate fees, bond requirements, whatever costs came up with this probate, whatever's left over will go to the beneficiary. Okay? If someone has no will, then you're leaving it up to the court to make all the decisions. They don't know what your intention was. They don't know who your beneficiaries are. They don't know anything other than they have to assess all of these assets and then start distributing it out to the beneficiaries. If there is a will, then it'll probably say the word executor goes with the probate. The word trustee goes with the trust. So in the will conversation, the executor, if you don't have a will, the court's going to choose this person to execute your will. If you do have a will, you've already named that executor. It's also called a fiduciary position, right? Personal responsibility. So if you have a will, you probably already named your executor. So that person or the executor that the court appoints, that's their job to figure out all your assets, all your debts, pay off your debts, make sure your taxes are paid, make sure the court is happy with all the documentation you're required to give to the court, get a release letter from the IRS that the IRS bill is paid, then the court will say, okay, now you can give money to the beneficiaries and you can close this estate. That process can take 6 months to a year, to a year and a half, to 2 years, to 2.5 years, depending upon how large this estate is and how extensive it is. And everything we're talking about is what we want to avoid, right? We're talking about what we want to avoid. What does the executor have to do? Well, they got to do everything I just described. They have to gather up all the debts, all the liabilities, notice all the creditors, notice all the beneficiaries, figure out what property is going to go through probate and which property doesn't have to go through probate, and provide all the accounting that's required to the courts. Some people try to do it themselves. A lot of people will hire someone to help them. For example, I have probate cases, and I have one case that is up in the mountains, and they hired me to handle it. So what I do is I file the documentation, we wait for a hearing date. At the hearing date, we're allowed the authority for the appointed executor. And the executor could be usually a family member or a friend. So this particular case, they chose a good friend. This person will appoint the executor. They'll be given letters. These letters are documentation, which I'm sure you've heard of these letters, that will give him the authority to start selling the house, selling the property, start moving forward on the probate, and he's responsible for it, but I am been hired to help him along. Not all property is subject to, so anyways, you gotta keep track of the property. This is what your job is when you're executor. You gotta keep track of it. You gotta safeguard it. You might have to change locks. You gotta manage the day-to-day affairs of the estate. You gotta pay taxes. You gotta pay creditors' claims. You gotta distribute the remaining asset estates according to the will. That is, if there are will. This particular case that I'm dealing with, there was no will. So throughout this whole process, there are procedures you have to be accountable to the court for. It's a lot of work. Now, not all property is subject to probate. To figure out which property is subject to probate, you gotta know when most property that is jointly owned, like joint tenants with rights of survivorship, when it's owned like that, or joint accounts, banking accounts, as you know, that property will automatically go to the other person. So that doesn't need to be probated because we already know where it's going, right? Because the deed says one person dies, the other person gets the house, and the other person dies, the other person gets the house. So that doesn't be probated, that's clear. And same with banking accounts. But I do want to tell you something about, are you familiar with the word step up and basis?
Yes.
When you're titled as joint tenants with rights of survivorship, you won't get that step up in basis. You only get 50%. So let's say we're married, we buy this house, we only spend $20,000 on it, and 30 years later, the house is now worth $40,000. We get the step up in basis, and that the value will be based on current value, so we have a less tax margin rather than when we only bought it for 20 grand. When you are held jointly with rights of survivorship, upon that death of the other joint party, you only get 50% of that basis. So that is something really valuable to tell your clients because they want to get with their tax person or attorney to figure that out because that might not be what they want, and most people don't know that. If you have questions, call me anytime we can discuss this further. That covers that. So, how do you begin the probate process? We file a petition for probate. We notify all the potential beneficiaries. We give a copy of the petition to all the potential beneficiaries, and we have to give notice of death in the newspaper. And that's got to run for 30 days, and we got to let everybody know. Once all that procedural is done, then the courts will allow us to give authority to someone to start selling and handling. And all that happens after our first hearing. And this is timely. A first hearing might take 2 or 3 months. Inventory. So when you have a will, once the will is validated, then you get officially appointed as an executor if there is no will. And you got to list all the estate property, you got to list the fair market value of all the property, real estate, stocks, artwork, antiques, all might need to be professionally appraised, so that's going to drive up costs. Anything that is of a minor value, executors can usually value that on their own. You'll be responsible for securing the property. Like I said, you got to take care of it. You might have to change locks. You might have to manage the real property. You might have to sell assets to raise cash to pay creditors. You will also establish a bank account on behalf of the estate, and you need to get a federal tax ID number of the estate. So I'm still talking about the jobs of the executor of someone who is in probate. Also included in the inventory is a listing of all the bills, all the debts of the estate, the amount of each. You as executor will notify all the creditors that the death has occurred and that there is a deadline for them filing a claim with the court that that estate owes them money. So we're still talking about the probate process. Handling creditors. As the creditors' claims come to court, you'll review them. You'll either accept them or reject them. If you accept them, you'll pay them and you'll tell the court. If you reject them, the creditor can come to court and explain to the judge why they disagree with you rejecting this debt, and the judge will decide if you have to pay that debt to that creditor. After you've got all of the claims against the estate paid, you will prepare a final inventory and submit it to the court for approval. What about taxes? So you do have to take care of the taxes. The taxes are paid out of the estate. You're going to submit all the forms to the IRS. If estate taxes are owed, you submit a form called the 706 to the IRS. And for any of you that have clients that might have a lot of money, $11.8 million is how much you can have right now to avoid estate taxes. That's going to change, I think, in 2025. So
Go up or down?
it's going to go up. No, down. Go down. If you've ever heard of DSUI, the deceased spouse unused exemption, so if two people are married, one person dies, if one person owned $5 million and the other person has $7 million in assets, and the person with $5 million in assets dies, the person with $7 million now has $12 million in assets, which is well over that 11.8. So now there's some taxes to be owed. Well, the person that's still alive can elect what's called the DSUI election. And just know that if you're dealing with people in that arena, this election would allow for the person that's still alive to use the exclusion from the person that passed to avoid paying those taxes to hold on to more of their money. Just know it exists. It's called the DSUI, the deceased spouse unused exemption, and it has to be filed within 9 months of death. So if you come across someone that has those higher wealth numbers, just want to say something like, you know, I know you got some stuff coming due in 9 months. You want to get on that. It's called the DSUI. It's called the 706 tax form. That would help them out a lot to maybe take that election. Errors along with that are very painful for people, which is why I'm spending time with you now. Just read it right here. It'll give you enough, and you can always call me to talk about it. The final accounting, after all creditors' claims are handled and taxes are paid, you prepare a final accounting for the probate court, and it includes all of the initial inventories of assets and liabilities, information on any property that's been sold, a statement of earnings on investments, as well as a record of all the creditors' claims, what has been paid, what hasn't, and what has been paid in taxes. So it's a full, thorough accounting that you must give to the court. The final accounting also totals the remaining assets of the estate and provides the court with an itemization of proposed payouts to beneficiaries. Now, not only is the final accounting submitted to be approved by the court, each beneficiary also has to approve the final accounting. If a beneficiary disputes the final accounting or an appraisal or a debt or something, then the beneficiary and the executor would go to court and talk to the judge, and the judge would decide on that matter.
Question.
Yeah.
This, what we just went over, this applies to the no plan and will? Or does it apply to all those?
It would apply to no plan and will.
Okay.
I'm gonna throw some of this in, but I wanted the meat of the presentation to be probate because that's what I was invited to be able to come and talk about. So we're talking about no plan or will. No plan, you're going to probate and the court picks out everybody. Your executor, they figure out who is related to you, they handle everything. So you're still going to probate. If you have a will, you're still going to probate. You just already told the court, this is my executor, these are my kids, these are my fees, this is where I want to have my stuff. You dealt with some of the stuff. But all the work I just described is the same for both scenarios.
Yeah, Jennifer, does it get real messy when someone inherits a retirement account?
Well, retirement accounts, those aren't probatable. I think they're in here somewhere. Retirement accounts, like 401ks, and depending on the 401k, if you and your clients have beneficiaries, designated beneficiaries, right, which you should have in your 401ks and your SEPs and some of your retirement and pensions, those monies are automatically distributed to those beneficiaries. They don't go through probate.
But do they have to
Same with life
do
insurance.
they have to cash those out within a certain 10-year period of time or something?
It depends on the pension. Yeah, so if you
Well, I
need
mean
to-
like an IRA or a KEO or
Usually rolling them over is the smartest thing to do.
Yeah.
But I can always review it if you need me to, and then tell you what I would do. Usually rolling over IRAs is the smartest thing to do, depending on factors like age and, distributions and all that goes along with that. But yeah, no, usually pensions, IRAs, insurances with designated beneficiaries, stay out probate and just go straight to that person. But then you also want to deal with taxes and income tax and all of that.
So with the will, is there a certain way it has to be drafted? And like, will the court, like a family may think they have one and then the court says, no, this isn't a valid will? Well, like what does that look like?
Well, they have to know, there's 5 rules from law school, I really can't remember, but they have to know who they are.
Okay.
They have to know what their bounty is, meaning who do you want to have your stuff? They have to know what their stuff is. And so as long as that's clearly articulated and then it's signed, has dates,
Okay.
those are called valid holographic wills that are found at home and addressed or handwritten by somebody. Sometimes those are admissible. Other wills ideally have 2 witnesses, and the witness isn't reading the document. Notaries, witnesses, we don't care what they think about the document. We're not asking them to check the validity of it. They're just looking at this person as of their own free will, has their capacity, and is willingly signing this document. So those are
Okay.
better to have 2 witnesses verifying that.
Okay.
They'll be stronger. But the other kind holds up too, that valid holographic type that I just said that you can write it out by yourself. It just depends. If the judge is comfortable with this person,
Yeah.
had it, I'll talk a little bit about how problems come up. So I want to talk about how much it's going to cost. And I'm doing well on time. Are you guys bored yet?
No.
Okay, good. But I'll answer that because I got some cases. Usually stuff like that comes up with when you have, you could have good friends or caretakers or non-family related people actually taking care of somebody that is in need. I'm sure you guys see it all the time. There's so many people that need help and aren't getting it from their kids. So someone else could step in and help, and that person could change their mind, change their will, and say, you've helped me so much. You take care of me, you drive me to my doctors, you keep my house clean, you feed my cats, you help me pay my bills. I love you so much, I'm gonna leave you my house. And they're gonna make a change in their will to this person that helped them. And then they write it out, I want to leave my house to this person, and then they pass away, and the family that never paid attention to this family member for 10, 15, 20 years, showed up at Christmas maybe, wanted some money in a Christmas card, only came around when they did it alone, would be the one that would say, that's undue influence. You put my family member under duress because you threatened not to take care of them and alienate your affections and leave them, right? That kind of stuff is real and happens. But you can see the way I said it, what side I'm on,
Yeah.
happens all the time. All right, so how much does this cost? So court filing fees, anytime you put anything in the court, you gotta pay for it. It runs, around $450 on down, depending on what you're filing. Attorney's fees are the same as the state fees. Appraisal fees, you have to appraise very valuable things, racehorses, antiques, jewelry, antique cars, real estate. You gotta get them professionally appraised. The court's not gonna take a layman's person opinion on how much something of value is worth, okay? So you gotta pay for that. And if there are disputes, then you got additional attorney's fees. So 2 siblings of 3, one is the partier, the family person, house was raided by the DEA, that kind of life. Living off mom and doing everything I just said as far as, putting pizza on the counter and letting it be there for a week and mom's supposed to eat off of that for a week. Having the hot water turned off and mom has no hot water to take a bath. So that's what's going on with daughter and mom in Orange County. The other siblings are out of town, but they call, they check in, they love their mom. And mom dies without a will. Both sisters want to be the executor. They want to be the one the court appoints. Let me handle this, let me sell the house, let me do this the way mom would want it. We will assess the value, we will distribute it a third, a third, a third. Those sisters fought each other so harshly. One would have clearly won because she had a clean record of good credit, because sometimes you have to get a bond. When you have fighting in families like this, or there's good reason for the judge to want to bond that person, and a bond, as you know, is money that you pay. If I'm chosen as executor and I got to sell the $700,000 home, I got all this money and I got a fiduciary account, my name is on it, and all this money is looking good to me, and I want to take off and run out of my life and go to another country, and I take all this money and run, right? The court bonds that to prevent that from happening, so that doesn't happen. I've never had it happen, but that's the point of a bond. Anyways, this story, those girls just could not get along. They fought like crazy. And so the fees were going up and fighting. She had to get bonded. It's a couple grand to bond, about $700,000. They just decided, no, they're gonna back down. My client, the one that would have gotten it, said, I'm not gonna live my life finding my sibling for the next 3 years while I try to sell it. It's not worth it to me. Some people just don't wanna spend their life fighting like that. So they backed out. We withdrew our petitions, and then now we're appointing a third-party neutral arbitrator to maintain family peace so that the situation doesn't explode.
Who decides on getting bonded? Like, how's that?
Well, for my cases, I can,
Okay.
the attorney, I can hire. If you have a bond reference, I'm happy to use it. I just shop, I can hire whatever bond I want. If the court requires me to have a bond, I just get one. Yeah,
You said 700,000, is that just for the example, or is that?
that was my example.
Okay.
So you asked me how much things cost. So here's, I love it. So for you guys, I threw in these, so you can play with this. So, but how much does it really cost? All right. So, someone passes away. The estate's gonna wrap around, their arms around the value, and they're gonna assess the value based on all the ways we just talked about it, whether you ever will or not. That number, when it's all said and done, whatever it is, you're gonna say, the fees are 4% of the first 100,000, 3% of the next 300,000, 2% of the next 800,000. So you see it, if you pull out your calculator and add this up, it doesn't take much to get to 150,000 bucks on an average $1 million estate. And then for 1% for the next $9 million, 16% for the next $15 million. So probate work is very lucrative. I'm hoping to retire my probate work. I'm saving it. So I would love to handle your probate work, but really let's think about the tragedy. We've been paying our taxes our whole life if we just had a simple trust.
Yeah.
And put our assets in the trust. After we bought our house, we would have avoided this whole mess. And not only dragging our family through the horrid nightmare of probate while they're trying to bereave the loss of someone they've loved their whole life, rob them of that sacred opportunity just to bereave normally without financial pressure, but they're also going to be paying out. So let's say we got I just did a number for somebody, I think I figured it out this morning. He's a realtor, he wants me to do his trust as a child, needs to appoint a guardian. If you have kids that aren't 18 yet, you can need to have a guardian in your trust. I figured out his probate fees are going to be $180,000. So when you do the math, okay, let's say you come up with a number. Let's say you come up with 90,000. Oh my gosh, okay, 90,000 off the top because they're going to go to the state of California. Well, double it because the attorney that gets the job gets the same fee.
Yeah.
That's why we want to do a trust.
Yeah.
Yes.
It happened with a KW agent, you guys, a different office during COVID. Young 23-year-old couple, just got married. His wife got sick, perfectly healthy, and she passed away at the age of 24. The home was in her name only. The home that they bought together for the marriage and the family. And he had to deal with this because they didn't think that they needed it. Because they were so young.
People, we don't as a society
Yeah.
get up and live our life thinking, I really should think about my death, right? We're just trying to get out of bed, get dressed, get out in the car, get to work, have some breakfast, take care of our family, take care of our loved ones, pay our bills on time. We're just trying to make a living and do our best in life. We don't think, oh, and it could be today for me going home, for any of us.
Mm-hmm.
But it does need to be addressed.
Yeah.
I'm very curious. You said you went back to law school at what age?
47.
At 47?
Wow. I don't know, ignorance was bliss. I didn't know what I was getting into, seriously. I just jumped in, and by the time I got in, I'm just really, really, really stubborn. I refused to quit is all. I'm not smart. I wasn't the brightest light bulb at all. I just grind through it, refused to quit, and yes.
That's fantastic. So, that's great. Start a career then.
Thank you.
That's awesome.
Yeah, it changed my life. So, special concerns. So, can a will be contested? Yes. If a beneficiary doesn't like who was appointed, the executor, or doesn't like anything that's going on, they can go to the judge and say, I don't like it, and contest it or fight. What makes a contested will successful is like we talked about. The document may not be properly signed, or it may not be properly witnessed, or it doesn't reflect the actual intentions of its maker. That's where the judge has to really dive in and figure out what was the actual intention of the person that was writing this. Intent behind. I have a case right now. It's a heartbreaking case. I love and believe my clients. They're in their 70s. Work hard their own life, build up their businesses, raise their boys, send him to Catholic school, really good to his sister, loves his sister, always takes care of her. She passes, she has this trust. She's always told him, I want you to have everything, bro, because they're the only two. And she wrote up her trust in such a way there was a little ambiguity. Ambiguity means, it can go both ways. And sister dies, my client, brother, dad, abdicates, steps down. This is too much, I don't want to do it. Son, I love you, I appreciate you, I built a company, you've taken it over, I think you're super smart, I totally trust you, I put you to Catholic school, could you please handle this? Sure, Dad. Son went through, and don't worry about it, I got you covered. And so Dad's just waiting, for his money to come and all of that, and it turns out son just took all the money, gave it to himself and his brother. And when they hired me, you know how heartbreaking that could possibly be for the dad. And so now we're suing brother. So, can things be contested? Sure. And what I'm doing right now is called trust administration. So we talked about this. You cannot be an executor if you're under 18, a convicted felon, or mentally or physically incapable of fulfilling the duties of an executor. Obviously, you get to that without having to talk about it. What do I do with insurance policies and pensions? Sir, on the back row on the far left, white hair, beautiful beige cream sweater. This right here says, the same is true of pensions, IRAs, certain retirement accounts. They generally just get paid out to the designated beneficiary. But we just need to check the plan very carefully to see if there's something different about it and make sure that we cover any estate or income taxes still from that money that goes straight to the beneficiary. What happens if there's property in another state? It's called an ancillary probate. So you can have a client that owns a couple properties in California, one in Arizona, one in Tennessee. Probate's going on in all those states by an attorney in that state. Yeah. So it's very messy, like an entangled octopus, and expensive.
What if it's in Mexico? Like properties in Mexico?
So I've got a situation right now. He's got property in Mexico and property here, and I can handle everything here. And then he'll fly in and sign and notarize. And then he's got to deal with, and I got people in Mexico I've been working with, he's got to deal with this Mexico stuff, because it's a whole other country, a whole other set of laws. And so if I put his Mexico property in this California trust, first of all, it's malpractice. Second of all, it just won't happen, nothing will happen to it, it's not going to protect it in any way. So you got to have two, one in Mexico, and then one in California. That's a good question. I got that going.
What's the cost of a trust to avoid all this?
I'll get to that. You want to know what the prices are? Yes. I'm doing really good on time because we started at 2:05. I still have 25 minutes left, so I'm going to finish my presentation, answer your question, but we're doing really good on time. What if there's no will? I think we covered that, right? It's called intestate. And you need the court to appoint your administrator. You need the court to figure out who your beneficiaries are and where your money should go. I just got a case where a woman inherited a home from someone she never met. a cousin. This person passes, he's never married, no kids, no history, so people are looking, sheriffs are looking, people are looking, what are the people out there that do that job? Look. And all of a sudden she just gets a letter, she calls me, and now she's gonna inherit this house because there was no will. So they looked through all the steps of looking for the rightful heir, which takes a long time. And we finally got down and found this woman that had never met her cousin. She gets this house.
Because she's the next of kin.
Yeah. Wow. Yeah. Like the guy that, I think is DHL, DHL airplanes.
Yeah.
I don't know if you know anything about him. There's a really good documentary on TV. He was very much a player, a worldwide player. He had a lot of women, and there's word that he had a lot of children out there. So when he passed, I don't think he had an estate plan. And so there were people that were putting up signs and posters in all the major cities, do you look like this person? Looking for all these kids that could possibly be related to him.
I'm his child.
Prince did not have an estate plan. Prince did not have an estate plan. You did not know that Prince did not have an estate plan. And they're still, because everybody comes out of the woodwork, right? I had sex with them one night, this is our child. You just, it all comes out. So, yes. All right, so, and generally, if there's a surviving spouse or children, generally it's gonna go there. It's not like it's gonna disappear from the family. But as you can see, it's arduous, it's painful, it's avoidable, it's expensive, it's not necessary. You can completely not have to go through that. So finding help, what I recommend for yourselves and for your clients is someone that listens really well and is responsive to their needs. And I hope that someone could be me to help you, to help your clients. I would beg of you to, if you have things in your life you're working on, committees and projects or opportunities, I love giving these workshops. I have many different kinds of workshops. Probate is one of them, and I'm happy to share, bring lunch and bring handouts and just teach. So sign me up as a speaker for anything you've got going on in your life. And please teach your clients. When you're having those conversations, please teach them about getting trust. Tell them how important it is. Just speak from your heart.
It's a good reason to call your database. It's an excuse to call them. If you're embarrassed to call them, you can add value. Say, hey, I met this amazing attorney, and I was just wondering if you have a trust. Oh, you do? Awesome. How was it? And then you go from there. That's a good excuse to call people.
And what you just said is what I was going to say. Today, the name of the game is value-added service.
Yeah.
By hosting this informative event for you guys, we're all demonstrating to our clients our heartfelt commitment to this high-level standard of service. Because what stands us apart? I go out and teach, right? That's what stands me apart from another attorney, right? What stands you apart? Yes, you bought this house. Yes, you got insured, but please protect your legacy. Make sure your kids and grandchildren get it. So let's put it into a trust and stay on them. Call them every 3 months. You might get a referral. Oh, my cousin, my friend, my neighbor said they want to sell a house. Did you get a trust yet? I keep lists of people say, yeah, I need one. I can't sleep at night. When I know someone doesn't have a trust, it bothers me. So I write it down and I call them every once in a while. Really, man? I got a friend that's a millionaire. Really? Really? And he always complains about the IRS.
You know the percentage of the people that don't have, I heard 11% only have a trust in the nation. Is that an accurate number?
That's really a good question. I was thinking about that, and I haven't looked lately. But there's a lot of people that have old trusts, okay? Very old. People will say, oh yeah, I got one. Well, how old is it? Is it over 10 years of age? That power of attorney, you guys, is going to get a lot of pushback at the banks and financial institutions. You've probably already dealt with it in some of your transactions.
So you have to update every 10 years?
You should. That's my general rule of thumb. Because things change. You know that. Laws change. Language changes. Criteria changes. The banking system is always changing. There's always something new to, for security and fraud and all this stuff. So old power of attorneys, update them. Healthcare directives, where you're going to lay out, how much life-sustaining activity do I want going on in my body while I'm starting to take my final breaths? Where do I want to be when this happens? Who do I want around me? Who do I want calling the shots for me because I can't talk to the doctor myself? That's the importance of the healthcare directive. And do you want to be buried in the ground? Do you want to be cremated? You want your wedding ring on? What is all the special stuff you want to have happen? Let's plan all this out. Old ones like that, too, let's update this stuff. So I like them to be pretty current.
Oh, that's good to know. And which one is the best one that protects the family the best? The living trust?
The living trust is, since I've got some time, let me see if I want to share you this.
Well, you answered that question. There's also a book on Amazon that I bought for myself to my clients, and it's called "I'm Dead Now What," and it's really cool. It's like $20 on Amazon, and I give it like as a closing gift. And it basically it's a book that tells that you fill out everything that you want people to know, like for your funeral, like where my passwords are, like just things. Hey, who owes me money? Hey, who I want them not to talk to and block on Facebook. You know, all the things are in there. Like for when you
And
die,
that's
I'm
why
dead now what? It's really cool.
That's why I would love to be part of your closings, you know, because if you guys are doing like a celebration, yes, because it's a big deal to close. I think it is, no matter how many homes you buy. And it's fun, so I can bring gift baskets and stuff like that, you know, to help them see and learn and understand and just celebrate the closing with you. But what I want to show you here, these are some more, we've covered a lot of ground really fast. Thank you for letting me talk so quickly, and I've shared a lot with you, but I just want to tell you really quickly here. Yes, the answer is a trust. A living trust. It's revocable, amendable, you can change it, you can fix it, you can rip it up, you can do whatever you want until you pass, then that final document is what holds up. And in that trust, think of that word trust like a jewelry box. I'm going to build you a contractually enforceable jewelry box, and we're going to put your jewelry in that jewelry box. Your jewelry is your houses. Put your house in a trust. Otherwise, your house is going through probate. Put your house in a trust. Other your house is going through probate. Please tell your clients that. Also, you've got issues with no remarriage protection. You've got a couple people that have blended families, past spouses, and other children. You can have a trust and you can set it all up, but if you're not really careful, you can go away and all the work and money that you created with this present spouse could go to his new spouse.
Yes.
You're in the ground and can't do anything about it. So that's something that when you build a trust, you get a good attorney that can help you avoid that happening, right? Does that make sense?
Oh, yeah.
And you advised, because when I got my trust, the attorney actually was like, if you were to pass away today, how old is your son? I go, he's 18. Would he be responsible with your assets? I said, absolutely. He would be like buying a Ferrari. Like, you know what I mean? Like, he's not going to be responsible at 18. So I put a clause in there that he can't get like money till he's 25. Unless he gets married, then I'll give him a little bit of money for that.
I love everything you've been saying to me because everything you said to me is exactly what I wanted to say next. Financial maturity, right? Windfall, woo! You know, new money syndrome, got all this new money, I want the new car, I want the new clothes, I'm gonna pay my bills, I'm gonna go on vacation. No, wait, how about we save it? How about we invest it? How about we not do all this stuff? So you can do that. I call them governors. You can put governors in your trust. They can get this much at 25, this much at 30, or this much when they graduate college, or this much when that's done. You know, you can lump sum distributions to avoid a windfall.
As far as the wills again, when you spoke about the will, what are some main points that we can cover with our clients? Because I think majority of our clients are like older than too. And they'll always say like, no, I have a will, I have a will. Like I don't want to go through a living trust. Like what are some main points that we can touch on and like just be like repetitive towards our clients about why the living trust, or obviously we know, but what a will doesn't do or like what.
That's really good. So you're asking me, you're in a situation with a client, you bring it up, and they say, oh, yeah, I have a will, and you feel like you should ask some more questions. You want to know how, you want to be comfortable with how do I probe a little bit more.
Yeah, just like obviously in a serving manner because we're here to serve people.
Okay, well, first of all, yes, thank you. What is your name?
Brittany.
If you're in a home with someone, is this scenario a homeowner?
Yeah, like I mean for all of our clients because we're helping them buy.
So the first thing you're going to say is, use their first name, because by then you're using their first name. You've sold them the home, they love you, you love them. Cindy, you have a will. You're going through probate. Do you know what that is? You don't want that. Spend some time. You should be alarmed, scared for them, nervous. Put on your list to call them every month or so. Do you still have a will? You're going through probate. Will you talk to Jennifer? She gets free complimentary consultations. You need to put this house in a trust. So this house, its proceeds get to your grandkids.
Cause you can say that the plans that you think that are gonna happen, they're probably not gonna happen.
How
Because
does
you're
it
going
work?
through
She's
probate.
going through probate.
Got
So
The living trust.
if you just sold this person's house and you say, well, how do you, what's your plan? What's your estate plan? Oh, I got a will. You just be like, woo, what? Like, really? No, we need to fix that.
Okay.
And call Jennifer.
I like that.
That's what I go on the inside with me.
Passes out.
All right. Another mistake people make in their trust, we're back to trust now. Some things we want to watch out for is make sure we're handling some tax stuff right. We're doing our IRAs right, our 401ks right. You never want to put an IRA or a 401k into a trust because it triggers a taxable event. It stays out. Everything else can go in, stocks, bonds, insurance policies, property, jewelry, cars, boats, motorhomes, bicycles, mopeds, motorcycles, yachts, condos, timeshares. I see a lot of people do it themselves, right? People want to sell their own home, buy their own home, and not use you. And then they are sorry because they didn't ask for the one-year homeowner's insurance policy, or they didn't make a list or anything was wrong, and they go move in and they got all this stuff that should have been fixed, right? There's all kinds of things that people do that cost them in the end. Hang on really quick.
Go ahead.
Really quick, because I'll forget.
No
What
problem.
we're gonna say. The do-it-yourselves don't have any of these bells and whistles I'm sharing with you guys right now, okay? It's not gonna be on the internet to this degree. It's gonna be more generic, right? And people don't know what to even ask these questions. Also, I have seen so many people say, I have a trust, and I would say, is it funded? Is your house in your trust? And they're just turning their head like, huh? Oh, I thought if I just created a trust, I automatically have my house in my trust. No, I fill out the paperwork. It's a quick claim deed. You know that. Preliminary change of ownership. I fill all of that. You need to sign it. I need to notarize it. I need to go down to the county recorder's office. I need to file it with the world law notice. You have a trust, and you have a house in the trust. That is when your house is in the trust. That's funding. Okay? And all the personal property of this person, everything they own in their names, their social security numbers, their birthdates, and who they have, and what they have, and who they're going to leave it to, it's not, you know that. It's not the county recorder's office. It just has their name of their trust and the legal description and the APN number of this house. That's a fully funded trust. So do-it-yourselfers get messed up.
I was just gonna ask a quick question. So as you mentioned earlier, you know, laws and everything is constantly changing. In regards to crypto, would that be fall under like an IRA or a retirement account? Or would it fall into like a probate situation or a living trust?
No, crypto we can put in the trust. I go twice a year to the summit with the academy, and
Okay.
I just went and we just had this full weekend of training, and one of them was all about crypto.
Okay,
So I'm learning now about how to handle crypto, and it's totally doable.
right.
So if you have something probably there, I'll hone in on it.
It would be more like another reason though to push a living trust if they say I have a will, but if you have crypto like that, you know, it's not really.
Well, I'm sorry, I didn't explain that right. If you don't own a home, you don't get a trust.
Okay,
Once you own real property, that's the line. When do I need a trust? When do I need a will? Do you own a home? You're in trust department. If you don't own a home, everything else will over here in will.
that's good.
Okay?
Really good for me.
Okay? Here's the line. Do you own a home? You're in over here in trust section. I don't own a home, I'm over here in the will section.
So our first time buyers after, you know, at the end of it, now it's starting to talk about living trust.
Yeah.
Exactly, gotcha.
Now procrastination is a big, big, big hurdle.
Because anything can happen, especially probably during COVID, right? A lot of couples die and the wife was not on the title or on the loan or anything. And next thing you know, she's basically homeless. They're gonna try to take her house out. Because there's still a debt. And they're not allowing her to make the payments.
And if they can't figure out a way to pay it, they're gonna lose the house.
Yeah.
I got two more planning mistakes. This one here, you know, in my legacy wealth planning trust, I encourage, I leave this beautiful book where you can put legacy memories. Favorite this, favorite that, favorite person, love that, learn that in school, learn that as a child, all of the stuff about your life that your children probably don't even know about you. The questions that are asked in this really great book that I give, it just creates a beautiful legacy of memories. I also show them in the back where they can list all the special things. You guys might have grandkids and you like to run around and say, I really like that necklace, Grandma. Or you might have a sister that says, I really want your owl collection. Just things like that. You can list them all. So my trust is very thorough with all those meaningful things, and that's what this is talking about. There's a lot to a person's life that you want to include in your trust, and that is your legacy. And then no plan to avoid family fighting over money. Families should be coming closer during this time and not fighting. So my plans are written and instructed in such a way where my intention is to avoid that. So it's very, very clear. So when I sit down with the client, my consultations are free, and I share with, first of all, I find out everything about how this is going on, right? What's going on? Marriages, children, blended. Do you have a child you haven't seen in 20 years? Happens all the time. I made a baby 50 years ago and I've never seen a child. Well, we should disinherit that child because that child will be able to take the money you work for. You've never seen a child. Yes.
Do you or somebody in your team speak Spanish?
Yes. So I take in all this information and then I start sharing with them all the different options. There's AA, there's all different kinds of trusts. I'm sure you've heard of them. And as you grow in wealth, you might have two people separate property, and they have community property. So they might want one trust for that spouse's separate property, another trust for that spouse's separate property, and they want a community property trust. It's like a little octopus, so we can move all this money around, take advantages of tax benefits, get money over here, take money over there, maybe give money to charity, depending on how much money someone has. But it can get very creative, very thorough. So I spend time with that with the client. People that are pet lovers, you can have a pet trust. That's what trust for your pet.
Billions or something.
Because, I'm a pet lover, and I could say in my trust, like my sister, Vicky, would you please take my dogs? Well, I don't know if she's gonna take my dogs and go to the pound after I'm gone. Right. So if I said pet trust, that dog has a trustee, that dog has legal rights. And the court will protect those legal rights to make sure that pet gets this, so it's really cool.
And you have to prove that the dog died of natural causes.
There could be a biopsy. A criminal investigation. And so then what I'm charging right now, what happened to the person that asked me? So I'm charging right now $29.95, $2,995 for my trusts. And I'll hold on to that price for you and your clients for a little while. Just remind me, because I have decided to raise my prices. And so you'll see that in my marketing, you'll see that in my life, they're gonna go up. But just remind me that I made you this promise, because it's not official and it could go on where I wanna keep my promise to you guys. Yes?
Oh, I would say that price that you're giving us, it doesn't matter how much property they own or what.
Well, it does a little bit, I'll tell you.
Okay.
So $29.95 will give them whatever they need. They have $1, they have 50 million bucks, whatever they need. And then in that price, I include one property that I will put in. Some people have 8 properties, 20 properties. I don't do all that.
Okay.
But there's another fee for that.
Okay.
Right, and I charge $275 a deed for all of that as it goes on and on and on.
Okay.
And then I create the trust, and then I come back with the client on delivery date, and I review it with them. And tell them, I want you to take some time, 30, 60 days, if you want to make any changes. I've made any mistakes. You change your mind about anything, I'll make all the changes you want for free, complimentary.
But did they sign the trust in that moment?
Mhm.
Because what if they die within the next?
The minute I've gotten it written, so when it's written, I call them, come in, and then, I notarize everything, we go over everything, it takes a couple of hours, and they go home with it, it's done.
Okay,
Right, we're good,
we're good.
we're locked in.
You can change anything within 60 days.
For free. They can change anything they want while they're alive.
Yeah.
And then once a year, I call my clients.
So if they have a second home and then you had it for additional fee?
Yeah.
What's
I
the additional
include
fee?
$275 a deed.
$275.
Yeah, I'm getting ready to raise my prices, but right now, just remind me what I'm telling you my fees are today.
Or 2,000?
Just $275. Yes, because it's what, 27 to $35 to record a deed, and I tack on my time, and then we're recording it myself, so, I was just gonna say something.
In the event that something happens to you, who would execute the trust?
Well, so, let's say, are you married?
Yeah.
Okay. You and your wife come to me and say, make us our trust. I say, okay. And you're gonna say, I own 10 homes, I got a bunch of horses, a bunch of kids, tell me what to do. So I tell you what to do. And I'm gonna say, well, who do you trust in your life? Who's gonna be your trustee? Because you and your wife are gonna be the initial trustees, right? In your trust, you are the initial trustee. If you're married, you're the initial trustees. You die first, you're in charge. You die first, you're in charge. However, you know, right? You're together on hot date night and get hit by a car and are incapacitated or killed. Who's your trustees? That word trust, to step in your shoes and fulfill the intent of your trust. So when I write a trust, I'm writing it to those people that are gonna have to follow that. I'm not the trustee. I'm trying to avoid that in my business. I don't wanna take that on. There's some situations that I might, but so far I haven't taken on that role.
You're the trustor.
No. I'm just the attorney that drafted it. You pick your trust. When you make your trust, you're the trustee and the trustor. You're everything. This is a living, breathing document. You can make changes. It's yours to do whatever you want. It's revocable. There are irrevocable trusts, but that's really not applicable to the average Jane and Joe. You're talking Bill Gates territory, Gettys. So we're not going to talk about that. Revocable. Okay, you want a revocable trust. You're the trustee. You're the trustor. You die, your wife is in charge. Your wife dies first, you're in charge.
But she would still need to see you.
Well, I would be happy, and that happens a lot. My clients come back to me, and I handle it. Like I've got one big trust that I wrote the trust. He died. The family came back and want me to do what's called the trust administration. So I show them how to walk through the steps. If you died and you didn't have a trust, you might come to me and say, we need you to handle our probate, your family money. I had a gentleman that died and the family just found my business card in his desk and assumed that I'd written the trust, but I hadn't. He came into one of the workshops, never did the trust, and so I'm having the probate. You know how it goes. But you, so let's say your cousin, you trust your cousin. You're gonna put your cousin down as your trustee. When me and my wife are gone, my cousin steps up, first position, and I want you to have 3. I recommend everybody has 3 positions. 1, 2, 3. And you can have more than 1 in your position. But that would be your trustee.
So at that point, they have to make a decision on who they want to administer the loan, on the trust.
At our consultation?
Right.
Yes.
Yeah.
So if you all are thinking about your trust, and you're wondering, what is she gonna need from me when I see you? You're gonna want to start thinking about, who are these roles of authority that you're gonna give to these people? Who would you give authority to? Most people give it to their children, good friends, cousins, sisters, brothers, children. I said children. I have a client that has 7 children, and all 7 children are trustees. So you can have more than one person as a trustee. I go kind of easy on that. It can get messy. But like, especially blended families, you can have 1 kid from each side. There's different ways you can set that up, but that's what I'm thinking about, who's gonna be my trustees. And don't think too hard, get your trust done, especially if you own stuff, you guys. You can always change these people. Life goes on, you might change your mind, you might not like that person might die. That person might not wanna do it. You wanna have first, second, third position. They don't have to legally do it just because you said that in your trust. There's no legal obligation they have to serve for you. You pass, they said, I don't wanna do it, they don't work. Although you'll have a compensation clause in your trust so they can get reasonably compensated, but they don't have to do it legally. And or they can be incapacitated or die before you, so.
How long does it take you to create the trust?
I can do one in a day. I can do one in 2 hours. But I generally ask, and it depends on the situation. Like I had a woman go down to the Amazon, and she wanted it done, so I did it real quickly. But it depends on how busy I am. I never take longer than 6 weeks. I usually like to do a 3-week turnaround.
Okay.
Right?
How much do you charge if you do the Mexico one, properties? Is there a different?
I can't do it. I don't.
Well, like the person, is it somebody in your office that does it or somebody over there?
I have referrals in Mexico that I could give you.
So I have my properties now
Uh-huh.
over there registered and everything's legit.
Uh-huh.
But they told me that if something happens here, they'd have to go over there. Is that true?
You need a trust set up in Mexico. Did I get your card?
I'll give it to you.
I'll give you a referral.
Okay.
I know who you should call. Okay? I don't know anything really about what's in Mexico. I just know who to call. I've been down to Mexico and they've done some things. I know a little bit about it, but not enough to guide you properly, but I can. I meant professionally.
We've all done some things, Jennifer.
Not.
I can tell you some stories.
And then I have a question regarding, once they use your service and they pay the $299.95, and you mentioned that once a year you call them, or do they call you once a year to continue to update?
I call once a year, and say, hey, what's up? There could be a divorce, a new marriage, a death, a new child. I changed my mind about that trustee, Jennifer. Don't like him at all anymore. He ripped me off. Or, who knows? I've got
I'd rather listen to my ex.
best friends suing each other, father suing son. Who knows what's going to happen in your life, you guys? Point is, we're going to keep it updated. I call my clients once a year. And there's two more things I do. If you guys found value in this, I would love for a good review. I would appreciate it so much. There's two other things I provide. So, your trust document, when you walk out of the office, it's ready to rock and roll. What if there's a fire or flood at home? I'll have a copy, but I could die going home from work that day, so I'm not a safe bet. So what I do is, I upload it into a portal that is secure, if you would like. And then I will give authority to whoever you want to have access to this portal. So let's say you, like your cousin and your brother, and they're your trustees. And you would want me to give them access to your portal. And of course, you'd want access, and your wife would want access. You would get an email saying, hey, you got access to Mr. Swanson's portal. I'll just leave it up. And click here, create your own passcode. So the people that you want to have access to your trust will have their own passcode, so they don't forget it in this safe portal in case you lose your document. That's free. That's something I include. Also, something that I also do is something called DocuBank. So, you're out. It's raining. Drunk driver hits you. You're on a hot day, and drunk driver hits you. You're in the hospital. You're incapacitated. Emergency staff is going to look through your stuff to find out who you are. In your wallet's going to be this card called DocuBank, and they're going to know what it is. They're going to know to get on. They're going to look it up, and they're going to see all the healthcare directives that I created for you. They're going to see what you want, what you've already discussed, what you're allergic to, who they need to contact right away, who are your loved ones, who are your emergency contacts. Very nice. I include that as well. Services. We talked about this value added on services, how to set us apart. Yeah, so I can help you, if you guys want to do an event, I can totally help you with all of that. We'll talk privately on how to do that. And I can help you with your closings, give a lot of bells and whistles to your clients, congratulate them. What other questions do we have?
I could just search you on Yelp, right? I don't think your QR code.
It worked on mine.
Oh, it did?
No, I just left her a review and I took a picture and uploaded it.
Okay. I'll find you.
Well, I'll tell you what, as a backup plan, that's why I did this last minute because I was having struggles, and so my team got it up. So that's why I asked you all for your cards.
Yeah.
No, we're Apple.
Oh, that's so bad. I'm so sorry.
Are you Apple
So, here's what I really want. There's a song like that. I really want your business card, because I'll send you my QR code, I'll text you. That's why I initially asked, because I didn't think it was going to be set up. And my cell phone is on my business card. Please shoot me a text. I'll send you my QR code. It would mean the world to me if you guys would send me something wonderful about this presentation. Any more questions? Anything at all?
I have one more.
Yes.
Does your trust cover the will?
Yes. That word estate plan means you get a full living trust. Right behind it, you get a pour over will. think of pour over will, like a pitcher of water. You go buy another asset, I don't know about it, we never put it in the trust. That pour over will is gonna pour that property through your trust and be distributed through your trust. So you have a trust, you have a pour over will, you have a power of attorney where you designate who gets to call the shots for you when you're incapacitated. That power goes away once you die. The power that they'll get comes from the trust. Then you have a full-blown healthcare directive with everything you want on how you want things to go.
So you're
You
like a
can't
one-stop
touch yourself.
shop.
Yes. And you also sign a document that releases your healthcare, your medical records to someone that's gonna be talking to the doctor on your behalf and you can't talk to yourself. All of that is an estate plan.
Do you trust a review of a will if I have a client that says, yeah, I got a living trust, but I don't really know too much about it, it wasn't really explained to me and it was done a while ago, or that?
I'm a trust for review.
Okay, that's good.
I'll be doing one Monday for a woman who,
Great.
yeah.
Thank you.
Do you recommend like spouses who have different assets, like their own assets before they got married, or when they got married they have like their own assets? Do you recommend, like separate them, like one spouse should have their own living trust, the other, or you could just umbrella them altogether?
Depends on what they wanna do, right?
I would like to say that I believe in the power of love and that it'll last forever.
Me too, girl.
Good one. And you got someone good and you want to commingle everything as it should be, as my parents did it. Everything's commingled, you know, everything goes into a big trust and it all gets distributed amongst the kids equally.
No.
That's a great way to go. And there are people that do that. There are other people that, especially if two people come into a marriage with a lot of money, that it's called separate property that they had prior to marriage, then I recommend keep it separate, keep it in separate accounts, do not commingle.
Or just get a prenup?
Yes, ma'am.
And then we set up a trust, and then
You worried about that?
and then we set up a trust that your separate property goes in this trust, the way you want it.
If you're a blended
And then
family.
the other person's separate property goes in this trust, and that's the beneficiaries the way they want it. And your kids' property assets that you guys have together, we put it in a trust, and you know, we'll get it what you want. And that's another way to go. Because if you divorce with separate property and you commingle it, and you're trying to get a divorce, it isn't nice, you gotta go through tracing it down together, and you pay for it, and make statements and all of that.
Yeah.
I know changes
You get it? Yes.
What about in the case that people are trying to sue?
It doesn't offer any liability protection, but I can certainly work with you on that, on how to do that. We get some EIN, set up some LLCs, do a little trade stuff, to insulate your trust inside of an LLC.
Oh, so you would look at that and say like, this, like if you're gonna put this in the trust and so-and-so may have access to it, like this is what you wanna think about, like later on down the road for your family.
This more is in play with businesses.
Oh, yeah.
People that want to put businesses in trusts, maybe put a business inside an LLC, move the LLC inside of a trust.
Oh, okay.
Have a little installation for liability, but also have everything flow through a trust. But what you just said, yes, I do. Assess and make recommendations. He's asking about businesses inside of LLCs. Because trusts don't